Well, I think we can start already. Well, ladies and gentlemen, good afternoon in Korea and good morning in Spain. I welcome you to the Madrid International Arbitration Center, or MIAC, and the Korean Commercial Arbitration Board International, KCAB International webinar called The Influence of Civil Law Jurisdictions and Their Businesses' Cultures on International Arbitration Practice. My name is Peter Barna, and I'm pleased to be your MC today. Thank you all for taking this time to join us and discuss the differences and similarities of these two jurisdictions and cultures when it comes to international arbitration practice. We will begin with a welcome address and introduction by Mr. José Antonio Caínzos, who is the president of the Madrid International Arbitration Center, MIAC. Mr. Caínzos, please, the floor is yours.
Thank you. Good morning, ladies and gentlemen, dear all. First of all, I would like to thank every one of you for joining us today in this interesting event about the arbitration practice in the two concurring jurisdictions, South Korea and Spain. The event today will be focused on discussing the similarities and differences, new trends and notable developments of international arbitration, aspects all of great interest. As president of the Madrid International Arbitration Center, and on its behalf, I would sincerely thank the Korean Commercial Arbitration Board for co-organizing this webinar with us, especially to Sue, Secretary General of KCAB International, for all your effort and time. I would also like to thank our speakers, Lucia, Enrique, Hyun-Jang, and Javier, for accepting our invitation to participate in today's event. It's a great pleasure to count on your participation. I personally consider this event as the stone that represents only the beginning of a fruitful and long-standing relationship between KCAB and MIAC, two innovative arbitral institutions for international dispute resolution, which focus on providing independent, transparent, and efficient dispute resolution services. Thus, I must say that MIAC is thrilled to be able to collaborate actively with KCAB, the arbitral reference in its jurisdiction, well known for its good practices and positive development. On top of the institutional relationship, both countries' legal systems are based on a civil law system, which operates as a disputed link for the two jurisdictions, the two institutions, and all the arbitration practitioners of South Korea and Spain. Because of the prior, I want to encourage all colleagues interested in arbitration to connect with the practitioners of other jurisdictions in order to explore its particularities and identify all the similarities of the two legal systems and the effects on the arbitration practice, which will come to a surprise to many, despite how far we are from each other geographically. All that being said, I finalize thanking you all again for being with us today, and I hope you enjoy the event and take advantage of this impressive panel. Thank you very much.
Thank you, Mr. Caínzos, for your welcome and kind words. We will next have the introduction or welcome address by Ms. Soo-Hyun Lim, Secretary General of the Korean Commercial Arbitration Board International, or KCAB International. Ms. Hyun Lim, please.
Thank you, Peter. And buenos días y bienvenidos a todos. 여러분 안녕하세요. 반갑습니다. It is a pleasure as the Secretary General of KCAB International to give these opening remarks to the first joint webinar co-hosted by the Madrid International Arbitration Center and the Korean Commercial Arbitration Board. In this webinar, we hope to bring together the international arbitration communities of Spain and Korea closer together through a discussion among a group of panelists who have been selected because of their ties to both regions. It is these sort of ties that we hope to nurture in the future, starting with the webinar of today. Since establishing diplomatic ties in 1950, Korea is now Spain's third largest market in Asia, with bilateral trade having reached 5.3 billion euros in 2019. Korea is also the third biggest source of Asian tourists for Spain, sending some 630,000 tourists in 2019. The two jurisdictions, as mentioned earlier by the president of MIAC, the two jurisdictions also share similar legal traditions in that both countries have a civil law tradition. Despite the potential closeness of the two jurisdictions, most of the interaction between the two in the field of international dispute have so far been done indirectly and through intermediaries, so to speak. Korean companies are avid users of international arbitrations, and many of the high-value cases at global institutions such as the ICC, LCIA, the Singapore International Arbitration Center, etc., involve Korean interests. I understand Spanish companies are also very active in the field of arbitration. So because of this background, if currently a dispute arises between companies in East Asia like Korea and a company in Spain or Latin America, it is more likely that they will resolve these disputes in the forum of these older and more established institutions. And in these forums, regardless of the legal traditions that they are more familiar with, companies of both sides will likely deploy and employ procedural practices and tools which originate from common law jurisdictions under the common belief that this is the golden standard of international arbitration. This is something that can be improved in many ways. Thanks to the recent establishment of MIAC as an international arbitration center in Spain, there has been an increasing awareness and interest in expanding direct channels between Korea and Spain in the field of international arbitration. For example, one could consider either country as a seat for arbitration in cases or disputes between companies from both regions or the two regions. Another possibility is to share common information on the pool of experienced arbitrators who are based on either Spain or Korea, and so that the parties can choose arbitrators who understand and sympathize with the expectation of international parties who have civil law background in common. Specific projects that we hope to create to improve further collaboration between Korea and Spain's arbitration communities is something that we are still developing and we are still exploring. But I am confident that the more interaction we have among our members of both communities, the more promising and fruitful the search will be. I hope today's discussion will be one of those many fruitful searches. And without further ado, I will turn back to the MC. Thank you very much.
Thank you, Ms. Hyelim, for your warm words, and you're welcome. Now, let me introduce the panel for the discussions of the influence of civil law jurisdictions and their businesses, cultures, and international arbitration practice. The panelists are Mr. Enrique Villaplana, foreign senior attorney at Union Yang LLC and president at the Spanish Chamber of Commerce in Korea. Then we have Ms. Hyunjung Lee, senior foreign attorney, partner at Bay, Kim & Lee LLC. We also have Ms. Lucia Montes, senior associate at the International Arbitration Practice Group in Cuatro Casas, and Mr. Javier Diez Hochleitner, partner at José María Alonso Abogados and law professor at the Autonomous University of Madrid. Now I'll leave the floor to the moderator so we can begin our discussions today. Thank you all.
Thank you, Peter. And as the moderator for the panelists, I thank all the speakers again for agreeing to join and sharing their insights about disputes resolution in Korea and in Spain, and overall in East Asia region and the Spanish-speaking community. So today, I would like to start with the first topic that we had discussed previously, which is an introduction to Spain and Korea as the seat of arbitration. Many arbitration users know about the traditional arbitration hubs that have been in the field for a longer time, but for Koreans, Spain might still feel unknown, and vice versa for Spain, Korea might still be an unknown jurisdiction. So I'd like to first invite Lucia to discuss more or less the legal structure of how arbitration is considered and dealt in a legal perspective from the perspective of Spain. And then later I will ask Hyunjung to draw parallels or compare that with Korea. So first I'd like to invite Lucia to talk about the legal infrastructure of arbitration law in Spain, please.
Of course, thank you very much, Sue. Thank you also to Jose Antonio and to Peter for their very nice words and kind introduction. I would like to start first of all by congratulating both the Madrid International Arbitration Center and the Korean Commercial Arbitration Board for the collaborative relationship that they are celebrating today. I hope this agreement will be very fruitful for both institutions and in broader terms, of course, for arbitration practitioners both in Korea and in Spain. I am also, of course, very grateful to both institutions for kindly inviting me to participate in this panel with these very distinguished colleagues, and of course to our audience, amongst who I see several very good friends who I salute. I will be now very pleased to briefly introduce the audience to my jurisdiction in Spain in terms of international arbitration law. So first thing first, Spain's regulation on arbitration is gathered in one single piece of legislation, the Spanish Arbitration Act, which entered into force in 2004 and has only been modified once in 2011. And in fact, the 2011 modification was quite a limited one. So we can say that the regulation has remained essentially the same for almost 18 years now. This is a positive feature of Spain's regulation for international arbitration, in my opinion, because it has triggered a wide body of consistent decisions in arbitration. It has enabled the Spanish judiciary to be truly familiar with this regulation. And at the end of the day, it has fostered predictable outcomes for cases seated in Spain. The Spanish Arbitration Act is not only a stable one, but a high quality one. It expressly follows the UNCITRAL model law on international commercial arbitration, to which it added some minor but relevant improvements. Therefore, this act is clearly in line with the most developed legislations on arbitration in other countries. Importantly, the Spanish regulation follows a monist doctrine, which establishes the same regime for arbitration, regardless of it being a national or international case. Monist regulations, as opposed to dualist ones, for example, as the ones followed in very well-known jurisdictions, I could quote France as an example, are to be seen, in my opinion, as a relevant advantage. Monist regulation simplifies very much the regulation in whole. It fosters predictable answers to the most relevant questions that can be raised regarding international arbitration. And more importantly, it unburdens for the foreign investors and foreign practitioners from having to analyze whether their specific case will qualify as an international one or not in the future. Regarding the relationship between national courts and arbitration, I would say that Spanish judiciary is doubtlessly supportive of arbitration. Foreign awards are easily recognized in Spain. Annulment of arbitral awards is very narrow and limited to generally pathological cases. I believe Javier will further elaborate on recent developments in this matter later. And in some Spanish courts strictly follow the rule of minimum intervention consecrated in Article 7 of the Spanish Arbitration Act. Spain is also a party to the 1958 New York Convention and the Geneva Convention of 1927. Both of them, as the audience know, foster a friendly framework for the recognition and enforcement of foreign awards in Spain, and they also facilitate recognition and enforcement of Spanish awards abroad. Spain is also a favorable jurisdiction for the purpose of enforcement once an award has been recognized. The only potential downside to this could be the 2015 Act on State Immunity and Privileges, which has rendered it slightly more difficult to achieve award enforcement against a sovereign state. But of course, this is only a concern for cases involving a state or state party and not a concern for commercial cases. Finally, I cannot bring this brief description to an end without devoting a couple of minutes to soft law. Spanish courts have always recognized the importance of soft law publications in matters related to international arbitration. There are many references, for example, in Spanish judicial decisions to IBA publications in matters such as independence and impartiality or taking of evidence. But I am especially interested in referring to homemade soft law in this point. This is to the publications and recommendations issued by the Spanish Arbitration Club, which is a major organization in our jurisdiction. Many of you might be familiar with it. In fact, the club's influence is well beyond the boundaries of Spain's jurisdiction, and it is now a big player in terms of promoting international arbitration, both in Spanish and in Portuguese. So in year 2019, the Spanish Arbitration Club launched its new code for best practices in arbitration, and this code constitutes a compilation of recommendation which the club offers, I would say, to the entire arbitration community. Its content is truly ambitious in two ways. Based first because of the wide range of matters regulated in one single code. The code sets forth rules which in the author's opinions should be followed by arbitral institutions, arbitrators, lawyers, experts, and even third-party founders. And it also annexes an updated model arbitration rule, set of arbitration rules, which, by the way, have been at the essence of the model followed by the Madrid International Arbitration Court in order to prepare and to launch its own set of arbitration rules. So here you see a good example of how this code has already had big impact in the real world. It also includes a model arbitration clause and model acceptance forms for arbitrators and experts. And second, I would say that the call is very ambitious too because of the very high standards that it recommends, both for independence, impartiality, but also for transparency and professionalism applicable to all participants in the arbitration process. So Sue, maybe I would suggest that we leave it here for the moment, and we can further elaborate on recent developments further down the conversation today. Thank you.
Thank you, Lucia. Yes, and the CEA is the entity that is well known outside of Spain and Portugal. Even here in Korea, we hear about it. And
good to know.
The newsletters as well. So, which explained sounds somewhat familiar for someone who has done arbitration in Korea, especially about the UNCITRAL rule or model law, and the unity and the ability to mobilize the arbitration community for the promotion of arbitration. So maybe I should turn to Hyunjung, who's been practicing in Korea in the arbitration area for some time, to share us about the arbitration infrastructure in Korea and how it feels like to be there in the scene. So Hyunjung, please.
Thank you so much, Sivan. I also want to join Lucia in thanking the invitation to this eminent panel and congratulating both institutions in starting this collaboration, which I hope is the first step to increased and closer cooperation also in the arbitration community. And as Sivan was already mentioning, there is already a lot of investment and commercial business going on between the two countries. So perhaps not the best remark, but us as arbitration practitioners, with increased business transactions, there is of course increased need for lawyers and for dispute resolution. So that one thing, would lead for an next. In any case, as Jose Antonio Gainzos also mentioned, although both countries are quite far apart geographically, actually it is not very far apart in terms of arbitration infrastructure and framework. As I would not want to repeat, but basically a lot of the things that Lucia explained also applies to Korea. So Korea's Arbitration Act is slightly older. The first Arbitration Act was enacted in 1960s, and it underwent a few amendments. The first one in the late 90s to adopt the UNCITRAL model law. So Korea is also a UNCITRAL model law country, which was it was the first Asian country to adopt the UNCITRAL model law. Then it also adopted the revised version in 2006. So that was the second major amendment to the Arbitration Act. Korea is also a member of the New York Convention. So many of the qualities in terms of the following the international standard in arbitration, domestic arbitration law applicable to international arbitration, and also for the interrelation between the courts and the arbitration practice in terms of enforcement and recognition of arbitral awards, minimum intervention, minimum supervision, trying to recognize and enforce unless there are major breaches of the due process and so on that are enshrined in the New York Convention, so following really international standards, enforcing arbitration agreements, and having very limited grounds for annulment. So all those things resonate in the Korean arbitration practice as well. Korea is also a member of ICSID, which joined in 1967, and this is the International Center for Settlement of Investment Disputes, which would be addressed later on today in terms of the investment dispute settlement. But and also both countries are growing arbitration users and growing as arbitration seat. I was actually surprised joining Korea and joining BKL in the practice of arbitration in Korea, how much actually of international disputes were seated in Korea using Korean law as governing law in the international contracts. So there is definitely an increase of that. And I believe this is similar and parallel to also the practice in Spain. More and more you see local firms acting as main only and lead counsel. There are more appointment of arbitrators of Korean nationality for both like arbitrations that involve Korean parties and also arbitrations that do not involve Korean parties. And I believe this is a result of both having a stable growth on arbitration and recognition of the rule of law and being arbitration friendly place in all of the aspects that are entailed in this. There's very reliable and strong support of the courts and the arbitration community, of course. There is one particular point, and I'm not sure what is the case in Spain, but in Korea, there is no particular arbitration court. I believe might be the same in Spain, but the courts and the judges are very familiar with all the applicable international arbitration laws, including the New York Convention. If I may draw back a little bit to the general topic of general topic of this webinar of the influence of civil jurisdiction. So of course, the basic parallel between the two countries is that both are civil law countries and they share the same hurdles and obstacles and challenges of being civil law countries that have to embrace the somewhat mixed and hybrid practice that is international arbitration. So we have probably the same difficulties in explaining our clients on what are the key differences of international arbitration practice from the domestic civil law litigation, including in terms of discovery, document production, and all these different special features of arbitration. And I think I may be running a little bit short of time, so perhaps I will leave some of the more particular details to Q&A sessions if if they're interested in knowing more about this.
All right, thank you. Thank you, Hyun-Jung, so much for this. After listening to both you and Lucia, it seems like both jurisdictions are fully matured arbitration friendly jurisdictions. All we have to add there is more disputes that are being overseen by either arbitration systems or legal acts in either jurisdiction. So the relevant question there, I guess, is how frequent are legal disputes? If there are any, and if there are those legal disputes, what type of transactions they come from, and how are they usually resolved? So that takes us to the next topic. And for this, we've actually tapped a speaker from Korea, from another Korean firm, who just by looking at the gallery may not look like a Korean speaker, but we have Enrique, who works with Yoon and Yang, a major firm here in Korea, who's seen a lot of action between both regions. So Enrique, could you tell us about what type of transactions you usually see when conversing with your clients, and what type of disputes and how they're generally resolved? So the floor is yours. I think you're muted, so if you could unmute yourself.
Yep, that's it. Sorry, had to reinitiate the sound. Well, thank you, Serhion, for giving me the chance to talk on behalf of a Korean firm. Thank you, Jose Antonio, and both institutions for this collaboration and the organization of this webinar. And also thank you for the distinguished panelist colleagues we have today here. I would like to talk about this topic, Sohyun, but I would like to add another perspective. When we talk about Korea and Spain, we are, delivering one missing region, which is, I think, based on my experience, that it's not recent. It's a trend that came over the last maybe 10 years, but it's an interesting question to deal with. But first, to talk about Asia, about arbitration, and about Latin America, because I leave the field of Spain and Korea to Hyun-Jung and to Lucia. I would like just to mention some of the main trends in corporate arbitration. And for that, we need to take first into account that increasingly parties based in Asia are selecting a seat of arbitration in Asia rather than looking to historic centers such as London or Paris. From our side, we have seen an increase in disputes arising from insolvency proceedings following the global financial turmoil of recent years. And at the same time, we have also seen an upswing in the number of clients seeking advice on possible claims against states arising under bilateral investment treaties. Also here continues to be work driven by disputes and litigation relating to the sale of financial products, investigations arising from increased regulatory oversight, labor disputes, and of course, breach of contract matters. Actually, there has been a dramatic growth in international commercial arbitration in Asia, and a rise in the number of cases administered by arbitral institutions based in Asia. More recently, as Asian economies rebound quicker from the last financial crisis, it has caused a surge in exports and outbound investment, but also claims originated within the pandemic, which has led to greater appreciation of the value of arbitration clauses in contracts. So as Asian economies slowly recover, companies are likely to arbitrate the dispute as opposed to 10 years ago, when parties were interested in a quick settlement due to the time and cost involved. So to see which is the origin, the parallels of the investment business relationship between Asia and Latin America, we need to go back a little bit to the history from the international perspective. international investment law has been, as people may know, has been dominated by capital exporting countries in Western Europe and North America mainly. The classic formulation of international minimum standard of the treatment of aliens and the right of the diplomatic protection appeared in the late 19th century and the early 20th century in the context of protecting Western European and North American investments in Latin America through arbitral awards that were named as a claims commission. Well, after the Second World War, Western Europe took the lead in concluding the bilateral investment treaties, also known as BIT, with capital importing countries. Later on, the US and Canada did the same based on the NAFTA investment chapter. Well, that was also a precedent of including investment chapters in the FTAs, the free trade agreements. Actually, Western Europe and America has also been active players in investor-state dispute settlements, which is known with ISDS. While in contrast, Asia has largely been rule takers in international investment law. And although the first BIT was concluded by Pakistan and the first BIT-based arbitration took place between a Hong Kong company and Sri Lanka, many countries in Asia have not been active in concluding BITs or FTAs with investment chapters. Asian countries have also kept a low profile in ISDS, both as a claimants and as respondents. Well, the geography of international investment law has, however, started to change during the past decade, and Asia countries have come to actively develop their networks of BIT and FTAs, being Korea, China, and India the most active in that. Years ago, Asia has been actively engaged in the regional rulemaking in international investment law. We have the Asian Comprehensive Investment Agreement, or the China-Japan-Korea Trilateral Investment Agreement, or the investment chapter included in the TPP. Those are notable examples. There is no to say that the changing landscape of international investment law in Asia raises a number of questions to be seriously dealt with. On the other side, about Latin America, I think that there is no opposition in saying that the economic and political interest of Asian countries in the Ibero-American region has been incessantly growing in recent years. So, for example, the investments of China, Japan, and Korea in the region have also become more relevant. Chinese investments are growing faster, but the stock of Japanese investments is still much bigger. China is still focusing on securing energy and raw materials for their industry. And although there is room for diversification in areas such as agricultural products and infrastructure. With very similar origins, Japanese investments are highly diversified nowadays. We have a clear focus in services. And meanwhile, the Korean investments in Ibero-America are rather diversified with predominance of manufacturers. It's clear that China is moving towards more liberal mechanisms for the settlement of investment disputes in order to grant legal protection to its investments abroad. As its role as a capital exporter consolidates. I mean, on their side, Japan and Korea, yes, also received huge amounts of foreign capital from abroad, but they became net capital exporters in the 80s and 90s. Another circumstance that we need to take into account is that China made the general ICS ID convention, which is the reservation to the Washington Convention, sorry. And that increases the scope of arbitrable disputes through a huge amount of bilateral and regional treaties with very different degrees of liberalization compromises. Korea and Japan on their side made no reservation to the Washington Convention and include modern jurisdictional means for the settlement of disputes in their bilateral treaties in the field of investments. Well, the three nations of Far East Asia have developed mechanisms for the facilitation of investments and obviously for the avoidance of disputes. And the origin for these non-litigation mechanisms in the field of investments, some people ask me about if they could be found in the Confucian tradition. But I think that, in fact, similar proposals have emerged in countries that do not share this cultural heritage, right? For example, Brazil. Unlike in Latin America, where political tensions coexist nowadays among supporters and detractors of solving disputes in international jurisdiction forums, well, among Far East Asian countries, there is no hesitation about the need of international jurisdiction mechanisms for dispute settlement as a means of last resort, and the cooperation and facilitation methods are complementary, although of great importance to jurisdictional ones. The current political trend in Iberoamerica seems to be generally favorable to the protection of foreign investments, with exceptions such as Venezuela. But I think that even in a cyclical conjuncture of political turmoil, contract-based arbitration is still possible. I think that the inclusion of survival provisions in bilateral treaties may also enable the use of treaty-based arbitration, even after the eventual denunciation of international treaties in the field of investments. So far, and this is a topic I leave on the table, there is no arbitration chamber clearly specialized in the administration of investment disputes between Asia and Latin America. Arbitration institutions such as KCAB, I think that should aim at administering these disputes. And the second issue is that I think that an arbitration chamber located in a third country with root relations with both regions, such as Spain, could be an additional warranty of neutrality for that. So I trigger everybody to push to that side.
Thank you very much. It's interesting to note the overview of how the dispute or the trend of the disputes among investors that are inbound and both outbound in Asia have developed over the years. And I noticed, as I was listening to you, I was reminded that although commercial arbitration has been around for a long time and merchants have been using it throughout the years, it is with the introduction of treaty arbitration, which involves governments, that sparks the general interest of arbitration overall, and it actually educates the general public on what arbitration is, and it indirectly encourages people to think about arbitration as an alternative dispute resolution method. And I think that's a very nice transition to the next topic under this general topic, which is how is the trend and how is arbitration being perceived in Spain, and how do you compare how it was perceived 10 or 20 years ago as now? And since this is a topic on Spain, I'll invite Javier to talk about the trend in dispute resolution and the growing interest in arbitration as perceived in Spain. Javier, please.
Well, thank you, Sue. Let me express that it is a great pleasure to share this seminar with all of you. Thank you very much to both institutions for inviting me to participate in this event. I will first focus on commercial arbitration and later on investment arbitration. As regards commercial arbitration, I would like to start referring to the growth in the number of cases submitted to arbitration in Spain after the enactment of the current Arbitration Act. There is also a growing tendency for large Spanish companies to resort to international arbitration based in Spain or abroad, which is a consequence of a huge investment made in the last decade in other markets, such as the Latin American market. A report prepared recently by a Spanish law firm shows that 45% of large and medium-sized Spanish companies have been involved in one or more arbitration proceedings in the last 5 years. With regard to arbitration based in Spain, a report from the Spanish Judicial Council indicates that there were more than 1,200 cases of enforcement of awards to the national courts in 2017, compared to something more than 700 in 2009, excuse me. These figures do not include, of course, award voluntary enforced, which are the vast majority. The growing interest of Spanish companies in arbitration has also led to many forums, journals, or meetings on arbitration. Suffice it to mention the creation in 2005 of the Spanish Club of Arbitration, which with more than 1,300 members and 30 international chapters all around the world. Secondly, I have observed in recent years a tendency for arbitration proceedings in which Spanish companies are involved to gradually accept procedural rules that deviate from our civil law tradition. I should mention that it's common today to agree on a document production phase, on 2 rounds of briefs, on the requirement that witness statements be formulated in writing, or on cross-examination in hearings. Thirdly, I would like to mention that the most important Spanish arbitration courts increasingly deal with international arbitration and aim to attract more international cases. This is why the Madrid International Arbitration Center was recently created by agreement between the Spanish Court of Arbitration, the Civil and Commercial Court of Madrid, and the Madrid Court of Arbitration. All these institutions bring together through MIAC the experience in administrating international arbitrations. Concerning international investment arbitration, I will refer to 3 topics. First, the end of Intra-European Union investment arbitrations. Second, the increase of arbitration proceedings against Spain. And third, the new free trade agreements concluded by the European Union. With regard to the end of Intra-European Union investment arbitrations, in 2008, the European Court of Justice rendered its judgment in the ADMEA case. The court ruled that investment arbitration based on intra-European Union BITs are incompatible with European Union law, insofar as they affect disputes governed by European Union law and the powers of the European Court itself. As a result of ADMEA, in May 2020, Spain signed a treaty with the other member states according to terminate all BITs applicable between them. However, Spain maintains more than 60 BITs, including a BIT with Korea. All of these BITs follow the classic OECD model. Moreover, it is worth highlighting a clear increase in the number of claims filed by Spanish investors based on these BITs, mainly against Latin American states. Suffice it to mention that since 2010, 42 requests for arbitration by Spanish investors have been submitted only to ICSID. Concerning the increase of arbitration against Spain, I should mention that until 2012, only 2 requests for arbitration were filed against Spain. However, since 2012 and to date, more than 50 arbitration requests have been filed, all of them based on the Energy Charter Treaty, except for one. In total, the claims amount to about 10,000 million euros. All these arbitrations are a consequence of various modifications to the promotion plan for renewable energy promulgated in 2000, which created a favorable investment regime for the sector, particularly in respect of tariff incentives. Following the global financial crisis of 2008, these incentives were largely withdrawn, provoking the presentation of the arbitration claims. As of March 2020, most of the arbitrations have resulted in awards against Spain, considering that the modification of the plan of 2000 breach the legitimate expectations of the investors and therefore their right to fair and equitable treatment. However, there are 6 hours favorable to Spain. Since the ACMEA judgment, the Spanish government, as well as the European Commission, which has intervened in numerous cases as amicus curiae, have been arguing that ACMEA doctrine should apply to arbitration with investors from other European Union member states. Arbitral tribunals, ICSID annulments committees, and most national courts dealing with set-aside proceedings have either not considered to be bound by ACMEA, or have considered that it does not apply to the Energy Charter Treaty, a multilateral treaty, as you know, to which both the European Union and its member states are party. However, on September 2, the European Court issued a judgment as a consequence of a preliminary ruling by the Cour d'appel de Paris, in which it states that Article 26 of the Energy Charter Treaty must be interpreted as not being applicable to disputes between an investor of one member state and another member state. We must now wait and see what impact this ruling will have on the ongoing arbitration against Spain. And finally, 2 words regarding the new free trade agreements concluded by the European Union. In recent years, the European Union has launched negotiations with several countries to conclude free trade agreements, which include chapters on investment protection, which provide for investment arbitration. In the case of investors of the other party, these agreements provide for the possibility that claims may be filed either against the European Union or against member states, depending on whether the challenge measures were enacted by the European Union or the member states. The conclusion of this new free trade agreement is due to the Lisbon Treaty, which gave the European Union exclusive competence to conclude investment protection agreements with third countries. To date, the European Union has concluded new free trade agreement with Canada, Singapore, and Vietnam, which replaces the BITs previously entered by the member states with these third countries. The BITs entered into by member states with other third countries will remain in force until they are replaced by agreements entered by the European Union itself. I want to emphasize that these new agreements do not follow the traditional OECD model, but rather the US model of 2004, going even further in preventing or preserving the regulatory powers of the European Union and the states party, as well as in the matters such as transparency of the arbitration proceedings or treaty shopping. But that's what I wanted to express concerning the new trends in Spain on arbitration.
Thank you. Thank you very much. Thank you for introducing a very hot topic in arbitration all around the world. I know it's a moving piece that many people are following, and it shows that arbitration is not it's not just still and stuck in what it was many years ago, but still it's a constantly changing and moving creature. So I think that takes us to the third topic that we had agreed to talk about, which is the developments of international arbitration. I know what we spoke about previously in this webinar relates to many of the notable developments, but I think it's worth talking about the topic in a manner that shows what the developments are from the legislative and the judiciary point of view, and also about the recent institutional developments in the field of arbitration. So maybe I can ask Lucia to come back and take us through what these recent developments are. Thank you.
Yeah, thank you very much, Sue. I'm very happy to take this question first, but I anticipate I will provide a very short answer, and I really look forward to Javier's comments and additions. So in a nutshell, There are no recent legislative developments in our jurisdiction. And as I said before, I think this speaks well of the stability of the Spanish legal regime for arbitration. In terms of institutional developments, it is my opinion that we are here today witnessing the most relevant one, which is the creation of the Madrid International Arbitration Center. Spain has clearly met for many years now the conditions to become a first-class international arbitration seat, but we were also missing one single strong arbitration institution that foreign practitioners could identify as the leading country for the purpose of cases seated in Spain. And thanks to the merger of the international practice of the Spanish pre-existing more relevant arbitral institution, which has given birth to the MIAC, we now clearly have this item which was missing, and this is having a real impact in the development and international exposure of Madrid as a seat for international cases. And finally, in terms of judiciary decisions, we have witnessed a very relevant recent development regarding awards setting aside, on which I believe Javier is going to further elaborate soon. So I suggest that maybe we can pass the floor to him.
Thank you. So Javier, if you could elaborate on the recent award or judgment.
Well, thank you, Lucia. Thank you, Sue. Well, I'm going to refer to a recent ruling of the Spanish Constitutional Court of February this year concerning the interpretation that must be made of the concept of public order as a ground for the setting aside of awards. Since 2015, some Spanish courts, in particular the High Court of Justice of Madrid, have been setting aside some arbitral awards on the ground that they breached the so-called public economic order. Public economic order would refer to certain basic rules and principles of contract law, such as bona fide, in cases needed of a particular protection. Based on this doctrine, the High Court of Madrid issued several judgments since 2015, setting aside awards that did not consider null and void certain clauses contained in contracts entered with financial entities that were considered by the Court of Madrid as contrary to the principle of bona fide. In the view of the High Court of Madrid, those clauses enshrined situations of imbalance, disproportion, or asymmetry between the contracting parties, either because of being one of them a consumer or because of the complexity of the financial product that was the object of the contract. The judgment of the Constitutional Court, to which I refer, rejects this doctrine, considering that the action of setting aside of an award has a very limited content and that it does not allow a review of the merits of the case. In other words, that it does not permit reviewing the facts and the law applied to the case. In particular, the Spanish Constitutional Court argues that public order can only be aimed at the analysis of possible breaches of the essential procedural rules applicable to the arbitration proceedings, such as, for example, the right of defense of the equal treatment of the parties. The Constitutional Court ruling represents, in my view, a very important support to Spain as a seat for arbitration, as it provides the legal certainty expected by economic operators. We cannot forget, however, the case law of the European Court of Justice, since its judgment, the EcoSuisse case. In EcoSuisse, the European Court concluded that an application for the setting aside of an award must be granted if the award is in fact contrary to the antitrust rules enshrined in the current Treaty of the Functioning of the European Union. In other words, it follows from the case law of the European Court that the concept of public economic order cannot be completely excluded as a ground for the annulment of an award, Although in the case of Spain, said economic public order must be limited to the European public order. Thank you.
Thank you very much. And maybe I'll give a few minutes back to Hyunjung, since we heard about developments in Spain, to share us the recent developments in Korea the last 3-4 years. Obviously have been a large change. So if you could share some of that with us.
Sure, thank you. So I briefly mentioned that the Korean Arbitration Act was more recently amended again to reflect various of the features of the 2006 Centro model law. Everything is moving towards more arbitration friendly in terms of broadening the scope of arbitrable disputes, the formal requirements of arbitration agreements being more relaxed, and giving more power to arbitral tribunals for issuance of interim awards or for process of aiding in the taking of evidence in arbitration, also giving them more power to express power to arbitral tribunals to award cost or interest, and simplifying procedures of courts for enforcement of arbitral awards. In addition, in the same year, in 2016, Korea passed an Arbitration Industry Promotion Act, so formally allows the Korean government to fund and support arbitral institutions, facilities, and practitioners in Korea. Of course, KCAB has been a central part of all this effort to grow awareness and use and reliance on the arbitral legal infrastructure in Korea. More recently, in 2020, a bill has been proposed that applies more to litigation for class action that can be brought in any area of law, which currently has been more limited for securities laws and securities transactions. And the opinion of the practitioners in arbitration has been that this undoubtedly would also influence and impact arbitration practice, where ideas will emerge on the possibility of formalizing also class action in arbitration and not only in litigation, which will be implemented formally in Korea. In addition, of course, we are all very aware of the ongoing still COVID pandemic, and Korea has not been foreign to that. And many of the hearings and everything have been turned to virtual, and it has been implemented very well. And at la par of all the other international arbitration institutions, I believe that KCAB has adopted also new rules that reflect emergency arbitration, expedited procedure in international arbitration. So we're progressing hand in hand with all the trends and standards of international arbitration. And Korea also, referring more to Latin America, perhaps linking it to Latin America and Spain and a little bit to trade. At the beginning of this year in January, the Korea's Ministry of Trade, Industry and Energy expressed that they would actively pursue expand the trade volume in Latin America. And they've been actively pursuing, and they've conducted within the government various conversations to pursue that agenda. And they've been continuing actively with the discussions to join Mercosur, to become an associate member of the Pacific Alliance, and also to reform the cooperation, strategic economic cooperation with Ecuador. And this is in addition to the various FTAs already in place with various Latin American countries like Chile, Peru, Colombia, Central America, and of course there is BITs with all of these different countries in the region, and also with Spain since almost 30 years ago, and the FTA with Europe. So with all of this, we will see more and more business going on across the borders.
Thank you. And I think you made an excellent point about the government's will, or at least the intent, to do whatever it can to help promote, increase the volume of trade between Latin America, Korea, Spanish-speaking countries, East Asia. So this, I guess, leads to my very last topic, which perhaps I might call back Enrique to talk about. So just freely, we're very interested, and I think both KCAB and MIAC is very interested on expanding the interaction and relation between the legal communities of both countries. What would be your suggestion as to what we should focus on in the near future so that there's more going to and fro between the two countries? Would be interested to know.
Thank you, Sohyun. Well, as I advanced before, I think there are 2 points based on what our colleague Hyun Jung was saying. Korea and Latin America, there is a long path way ahead of us, but we need to find out which is the best collaboration for getting those missing 2 points I already mentioned to solve them. I mean, there is no arbitration chamber specialized in investment relationships between Asia and Latin America. I think that this is a chance Korea has given the relationship between Spanish companies and Korean companies in those third countries. I think it's a good chance for Korea jointly with Spain to go in the same direction and to fulfill the needs in a region like Latin America, in which since years ago, the investments, obviously on behalf of Spain, but lately also Korea, throw the stone, kick off the course, and well, even though Chinese companies are already in Latin America, I think that there is enough room for Korea as well to get investments, make investments there. And then, of course, it's an opportunity for the two institutions to get on the top to deal with the potential disputes between the companies of the two regions.
Thank you. Thank you so much. I don't see any questions raised in the Q&A chat box. I think the speakers have been so eloquent that the curiosity has been satiated by most listeners. But we invite anyone who's been listening or who hears this webinar later on in recording to send either KCAB or MIAC any questions you may have about the contents of this webinar. So I know I'm very conscious of the time. We have already reached the scheduled time for this webinar. So for now, I'll turn back to the MC of our webinar to say, I guess, to send everybody off. All right, thank you.
Thank you, and I think that concludes the webinar, the influence of civil law jurisdictions and their businesses, cultures on international arbitration practice. I think, thank you, the panelists and the moderator, especially for the insightful panel discussion. I thank you for the organizers, MIAC and KCAB International, and a big thank you for all of you that followed us today. I hope you all have enjoyed these discussions as much as I did. And well, if you need more information about the organizers of this webinar, MIAC and KCAB International, I invite you to visit their websites, which are madridarb.com and kcabinternational.org.kr. So thank you all, and I hope you have a great day.
Thank you.
Thank you.
Thank you very much. Bye.
Thank you so much.
Goodbye. Thank you.
Thank you. Bye.